Currently, there are only a handful of remedies available to individuals who have been convicted of a felony under Illinois law. That said, however, there are more remedies today than there were a year ago. There are 3 ways in which you can restrict access to a felony conviction record and be able to answer no to the question, have you ever been convicted of a felony? Those remedies include filing a petition to seal after you have obtained a certificate of eligibility for sealing, or filing for executive clemency from the governor with permission to expunge. Currently, there are only a few felonies that are subject to sealing where you don't need to first obtain a certificate of eligibility for sealing. They include Class 4 felonies for prostitution, possession of cannabis or controlled substance, or violations pertaining to the use or possession of methamphetamine or steroids. When a criminal history record is sealed, the information is not actually removed from the Illinois State Police criminal database. Access to it by the public is restricted. Access to it by law enforcement, however, is not restricted. A certificate of eligibility for sealing applies to individuals who have certain nonviolent Class 3 and Class 4 felony convictions that are not subject to the current rules for sealing. Individuals are only entitled to receive 1 certificate in their lifetime for 1 conviction. Certain convictions that are expressly excluded include any violent felony offenses, as well as DUI offenses or offenses involving a firearm. So far, the Illinois Prison Review Board has not posted the procedures for applying for the certificate. It is my understanding, however, that starting in October of 2013, those procedures should be posted, and at that time, the board will start accepting applications for the certificate. Under the state constitution, the governor has the authority to grant somebody a pardon who's committed a criminal offense that is not subject to the other remedies. The way to seek a pardon is by filing a petition for executive clemency with the Illinois Prisoner Review Board. The board is responsible for then making a recommendation to the governor as to whether or not you should be granted the pardon. A candidate worthy of a pardon is someone who, in the first instance, has accepted responsibility for the crime. 2, can show that they've rehabilitated themselves. It might mean going into drug rehab, joining AA. For somebody else, it may mean that they went back to school, they got a GED, they obtain, skills that enabled them to be employable. And then the last thing that the Prison Review Board is always interested in is why the person wants clemency. The individual must be able to articulate a reason for why they need the pardon. The process from the point where you file your petition to when you actually get a decision from the governor takes on average between 2 and 3 years. Anybody can file. However, the rule of thumb is that the longer you've been crime-free and arrest-free, the more likely your petition will be viewed favorably. House Bill 3061 was passed by the Illinois legislature in June of 2013. The bill would expand the list of sealable felony offenses that would not require first obtaining a certificate of eligibility for sealing. The new felonies that would be added to that list include Class 3 and Class 4 theft, retail theft, forgery, deceptive practices, and possession of burglary tools. We should know by the end of this summer, the summer of 2013, whether House Bill 3061 will become law. And in that case, in the case that it does, it will go into effect as of January 1, 2014.